everyone. Brian Hengesbaugh, partner with Baker McKenzie in Chicago and Global Chair of Privacy and Security, here for part 3 of our series on what does the California Consumer Privacy Act really mean for human resources data. In part 1, we had an intro. In part 2, we had an overview of notice and choice. And now in this part 3, we're going to be talking about the access and deletion elements or pillars of the law. So if you're familiar with GDPR and the European privacy rules, within them there are rights for individual data subjects, and in our case, whether it's employees or contractors or other workforce members, to request access to the information that the company has about them. Now, as framed under California CCPA, an individual would have the right to obtain access to the specific pieces of personal information that the company maintains about them, plus a series of other information about sources of data, etc. In practice, what we're thinking is going to evolve is that upon receiving an access request, the company will provide a copy of the privacy notice that we talked about in part 2, along with then the content that one specifically has about the employees, the specific pieces of personal information. So you can see right away, and by the way, that access request goes to not only information that the company holds, but also any information that a service provider maintains about the company. So you can see right away there's a need to have good due diligence done to know where to go to get specific pieces of information about the individual. And then there's also a lot unknown about how this is actually going to be applied in practice. So, for example, one thing we'd have to be ready for is to the extent that there are emails or other unstructured files that may have various bits and pieces of data about an individual. That might be something, or portions of that might be things that need to be carved off and shared with an employee in response to an access request. So a lot of due diligence. There's very few exceptions, really, to when access needs to be provided. For example, you don't have to respond to an access request more than twice in any 12-month period. There's a broad carve-out if the access request is somehow manifestly unfounded or excessive. In those situations, you can either charge a fee, reasonable fee, or maybe perhaps even refuse to act, and I think those are going to be really significant issues. Typically, you need to provide access within the first 45 days of receipt of the request. It looks like it can be extended 45 days, and then in excessive cases, you can get another 90 days to basically make up your mind as to what you can provide. Again, the statute itself was written in a bit of a rush, and so it's not really clear how these time periods stack. Does that mean in totality we have 180 days at the outer end, or how does this play out? But nevertheless, those are some issues we're going to have to grapple with. Let's talk deletion for a minute. So also, employees, contractors, other workforce members can come to you and say, I want you to delete my information. Now, thankfully, there's a much broader set of exceptions to the deletion requirement than there were for access. So you don't need to delete the data if indeed you need the information to perform a transaction, for example, to make payroll, which the employee might actually want anyway. But nevertheless, detect security incidents, exercise free speech, historical research, other types of internal uses. So there's a number of exceptions to the deletion requirement, which we think are going to truly be critical, or comply with the legal obligation is another one that's very important. Truly critical when it comes to the execution of this. But you can see at a high level what you're going to need to do is understand where the data about employees, contractors, and workforce members resides, and be thinking through how could we delete some of this information upon request, and what would be almost our standard operating procedure for responding to these types of requests so that we can be ready to meet the timing requirements within the statute. And lastly, as with the access, the deletion request must be passed down to any service provider that you have. So you can see that in doing your due diligence on service providers, you're going to need to make sure that they as well can delete data upon your instruction. So there it is, comprehensive set of rules. Perhaps more to be clarified with regulatory changes or law changes or federal preemption or other issues, but certainly a comprehensive set of rules that are here to stay. Thanks.